This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569. I'm Spencer Mazyck, and joining us now from Washington, D.C. is Greg Stohr, Supreme Court reporter for Bloomberg News. Greg attended the third and final day of oral arguments for President Barack Obama's health care reform. Today, the justices heard arguments on the issues of severability and Medicaid expansion. Greg, let's begin with severability. What were the highlights from today's arguments?
Spencer, the clear consensus on the court was that more than just the mandate would have to be thrown out if the mandate was thrown out. The guaranteed issue and community rating provisions that the Obama administration says are inextricably linked to that probably would go as well. What's much more up in the air is what happens to the rest of the statute. The justices were very divided on that point.
Well, is it clear to the court, though, which provisions should survive if they get rid of the individual mandate?
No, not at all. There's certainly a feeling that there were some provisions in here that had absolutely nothing to do with the mandate. The Black Lung Benefits Act being reauthorized as part of this bill had nothing to do with the mandate. And there were certainly some justices who questioned, why are we throwing this? Would we throw this thing out because we're throwing out the mandate? But part of the problem was sort of figuring out how you draw the line between the Black Lung Benefits Act and things that are a lot more tied in. And some justices, particularly Antonin Scalia, suggested, I'm just going to vote to throw the whole thing out.
Well, did the court consider what Congress may have intended in terms of when the legislation was drafted?
They did talk about that, and there was a lot of discussion about what the test should be, whether the test should be something that tries to figure out what Congress meant to do, what a hypothetical new Congress would do, whether you just sort of look at the text of the law and try to figure it out from there. It's striking that after all this time, the court's been in this business for 2 centuries, they don't seem to have a real clear sense of what the test should be for when they sever provisions from a bill.
That is pretty incredible, Greg. But based on today's questioning, was it any clearer where the justices stood in terms of striking the individual mandate?
There wasn't a whole lot there. I did talk to one lawyer who watches the court very closely, Tom Goldstein, afterwards, and his view was that there was a question from Justice Kennedy that he thought might have given the Obama administration some heartburn, where Kennedy started his question by saying, assume that we're going to throw out the mandate. Now, exactly, whether he meant that
hypothetically, yes.
Hypothetically assume, or whether he meant that, take it from me, we're going to throw it out. It may have been closer to the former than the latter, but at a minimum, that was a potential signal. But in general, it was all sort of focused on the severability question and not the mandate itself.
And just one other question about the mandate, though. Did you get the sense that maybe there might be more support for the mandate if the justices don't want to determine which provisions should be struck along with it?
It didn't seem to feed back into that. There was no sense, and I was certainly looking for some sort of sense, that the justices might get cold feet once they realize that striking down the mandate might mean they have to strike down all these other things. That's certainly possible that could happen, but there was nothing from the argument that would lead one to conclude that was the case.
Okay, so let's turn now to the Medicaid expansion. Did the court seem to embrace the arguments for the coercion theory?
The court on this issue too was very divided. There was certainly no suggestion from the 4 Democratic appointees that they were inclined to say that this was unconstitutional coercion, but there was some support for it among the Republican appointees.
Did the justices question whether government would be forcing all states to expand Medicaid coverage, or would some states do so willingly?
That did come up to some extent. There was a bit of a sense in the argument in general that all these issues are sort of interconnected, and there was in the minds of some observers a sense that the court may not even have to get to this issue if it were to determine that the entire law had to be thrown out as a consequence of the mandate being thrown out.
No, that's an interesting point. They may not even reach this particular issue. And one last question on the Medicaid expansion, though. Did they see striking the measure as restricting the power of the federal government at all?
Well, that was certainly a thread in the argument. Congress has had, traditionally had this ability to put conditions on federal spending, and if they do say Congress cannot do that, no question that will be a new restriction on federal power.
And when do we expect to get a decision on all of these issues here?
The court's term traditionally ends, right at the end of June, and they could rule any time, but odds are it's going to be very close to the end of the term.
And one final question that I have to ask you, Greg. If you're the Obama administration, what do you think about the hearings that happened in the last 3 days?
They certainly did not go as well as you would have liked. I think they will take some consolation in knowing that oftentimes arguments are not predictive. And even if it seemed in court that the justices were leaning one way, this is an exceptional case, and it may well be that at the end of the day they come out a different way. So they had confidence in their case going in, and perhaps they will still have confidence.
All right. Well, we'll all just have to stay tuned then. Thanks very much, Greg, for sharing your insight with us.
My pleasure.
That is Greg Stohr of Bloomberg News. For more information on this or other topics, subscribe to BloombergLaw.com, and you can follow us on Twitter. Thank you for joining us. Bye, everybody.
Copyright 2012 Bloomberg Finance LP. All rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take any responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.